Okay, we're at Chapter 11, Remedies. This is one of my favorite chapters because it involves one of my favorite subjects, money. When a client comes in the door, one of the first questions they have, and the first questions you have, is how much money is this particular case worth? As a paralegal or a lawyer, you want to know because you want to know if the case is worth taking. As a client, you want to know because that is potentially money in your pocket. You need to think of remedies as tools that you can choose from. It's not as if there's one remedy that would work in every situation, or there is not really a correct remedy. There are a variety of theories that you can choose from that you can potentially fit the situation. So your job is to learn the different labels and how they apply, and then to be able to see their possible application in a factual setting. The book describes a split in American history between the legal and equitable world. Basically, what happened is there used to be two sets of courts, a law court and an equity court. And you could go to the equity court if the law didn't point the way to fairness for you and you wanted to rely upon equitable principles. In 1932, those courts were merged, and now the principles from the equitable courts are still applied in the legal courts. The major difference is that for equitable remedies, you don't have the right to a jury. So if you're seeking an equitable remedy, it's going to be a judge trial, and the judge will decide what is fair in the situation. If you have a legal remedy involved, you get a jury trial on that. And sometimes courts actually split cases down the middle, and they'll have the legal issues go to a jury and the equitable issues go to a judge, just to honor that time-honored set of principles in the split between legal and equitable remedies. Basically, money is a legal remedy. So when you say the word damages, you're thinking of a legal remedy and you're thinking of money. There are four main types of damages as listed here. The most common prevalent damage in all of contract law is compensatory damages. This is kind of the default rule. This is what is expected. And it's where the person is awarded the difference between what they were promised and what they actually received. The idea behind it is that the person is going to be put in the same position they would have been had the contract been completed as originally planned. They're not going to be in a better position, but they're going to be at least in the same position as if the contract had been completed. Here's a simple example. Spencer purchased a dozen eggs, but 3 of them were cracked. The appropriate legal remedy would be to put him in the position that he would have been if Safeway had performed, and that would be he's missing the value of 3 eggs. Notice that doesn't mean he gets 3 eggs. He gets damages representing the value of 3 eggs. He then has to go out and buy them. The time and hassle of getting a replacement is often not covered by the remedy of legal damages. Notice that this is not like winning the lotto. This is simply a measure of putting the person in the position they would have been had the contract been performed. It's not doing any more than that. The concept of punitive damages are intended to punish somebody. We often think of them in the tort world. A tort meaning an injury that you didn't bargain for. Somebody hit you with their car, for example. So for punitive damages, they're not available in Washington unless the statute specifically authorizes their use. In states that do allow punitive damages in the contract situation, you often need a tort theory such as fraud in addition to breach of contract to recover those damages. Breaching a contract is not something that you get punished for in the abstract. Fraud and doing bad conduct, those are things you can get punished for. That's the reason behind that. This is an actual Supreme Court case. Peter bought a new BMW that had been repainted at the factory because acid rain had etched the original finish. Peter sues in breach of contract and fraud and gets punitive damages of $11 million, meant to punish the car maker and stop them from doing this again. Washington is not a very punitive damages friendly state, and Washington would not have permitted this outcome. In this real case, the Supreme Court said that's too much punitive damages, and one person shouldn't get the benefit of all of the money uh, that is used as a penalty against the BMW manufacturer. Consequential damages are not the normal kind of damages that get compensated in contract. They require that the breaching party have been put on notice that additional damages could result from their failure to perform, and they therefore need to have foreseen that additional damages could be caused by their failure to perform. The book talks about a crankshaft, and the failure of the performance of delivery of the crankshaft meant that the entire factory couldn't operate. That's an example of consequential damages. It's damages beyond the simple replacement of the part that wasn't delivered. It's damages that go to additional harm. You will notice in most contracts, consequential damages are actually precluded. There is usually a limitation that says no consequential damages are permitted. You'll see that on everything from Pop-Tart boxes to table saw boxes. In this example, with the UPS's failure to deliver a part for a refrigerator, it's virtually certain that UPS has a clause that prohibits their being liable for consequential damages. And you sign their papers either directly or through the internet with a click-through agreement. That's what that's what the name is for an agreement where you actually sign through the computer. So compensatory damages in this situation would be the value of the part that wasn't delivered. Consequentials is the loss of the entire contents of the refrigerator. You see the difference? Some students report having difficulty trying to tease out the difference between a compensatory remedy and a consequential remedy. Try and think of these examples to help you. There is a common limit to all damage awards, and the limit is you can't get speculative damages. A court will not award damages that are speculative. Speculative means you're basically having to guess. So if a party is not able to come up with evidence as to its actual losses, for example, say they're a new company or they just don't keep good records, they may not be able to recover the full amount of their losses because awarding them damages without any concrete proof would be speculative. The example I have here is a new business, a Barbie doll business. The profits aren't calculable. You don't know how much profit a new business is going to earn in the first year or two of its existence. So new businesses often face this limitation. There is a fix for this. If you're contracting and you know that you're going to have a problem proving your damages, you could actually state what your damages, what you think they will be, using a clause called the liquidated damages clause, which we'll talk about in just a minute. Liquidated damages are parties' attempts to quantify damages that would otherwise be undeterminable. So there are two limitations to the use of these clauses. Number one, the courts say you can only use them in situations where it's hard to determine what the compensatory damages would be, such as in a new business, or maybe let's say it's a hotel that's being built and you don't know how many people would actually come and stay in the hotel, so you don't know what the lost profits would be. And that's one limit. And the other limit is ultimately whatever damages you come up with can't be unreasonable, i.e. they can't be punishments. They have to be genuine attempts to fix the damages in that situation. This often happens or works well in new construction situations. We're having a showcase house. We want to have a big party. Svetlana doesn't actually know what the damages would be if the workers miss the deadline in building that house. So she puts in a liquidated damages clause in the contract saying it would cost them $500 a day for being over the deadline. Now that's hopefully not her attempt to punish them, but it's her attempt to kind of guesstimate what the damages would be in that situation. And again, it's pretty hard to tell what the compensatory damages would be without the use of a liquidated damages clause. Now let's contrast a liquidated damages clause to a limitation of damages clause. Limitation of damages is just your standard thing that happens in a lot of consumer contracts where the manufacturer says, okay, if you have damages from the use of this table saw, we limit that amount to in contract to $1,000. Or maybe the more common situation, if American Airlines loses your luggage, you're limited to $500 per suitcase. So that's a limitation of damages clause that basically puts a ceiling or a floor on the damages that can be established. Parties are free to put those clauses in. The only time they will not be upheld is if they were unconscionable, which means so grossly unfair as to shock the conscience. Then we have the range of equitable remedies, which are designed to prevent unfairness and unjust enrichment. Unjust enrichment, obviously, is the concept that somebody gets something that they didn't bargain for. Here are the categories. We'll discuss each one. The first example is for an injunction. An injunction is when money damages alone would not fully compensate somebody because the subject matter of the lawsuit or the subject matter of the issue is a unique item. So an injunction is often paired with specific performance. An injunction is where the court's equitable power allows the court to order a person to do something or not to do something. In other words, court says don't flee to Peru with the golden egg. That needs to be subject to a determination here in the States, and you can't leave with it. Or don't destroy that and that old building. We need to keep it alive until we are able to determine what should happen with it. Imagine this situation. Angela purchased a '67 Mustang that was warranted to be sound, but it didn't run. Under the legal remedies, she could get the difference between what she paid for and what she got. Let's say she paid $10,000 and the car is only worth $1,000 as it is. So she could keep the car and get damages of $9,000. But would she really want that? No, she probably wants to undo the deal, and that would be rescission and restitution. Rescission means turn back. It means undo, go back to the beginning. Imagine the contract was never formed. Notice how that's different from compensatory damages. Compensatory assumes that the contract was completed, whereas rescission assumes the contract was undone and went back to the beginning and you refund the money she's paid. That is an equitable remedy. Reformation is where the court, out of its equitable power, takes what we call a blue pencil, because I guess they used to use blue pencils in the old days, but the court takes a pencil and actually changes the contract to reflect what actually happened or what the parties want or what the court decides should be the case. So imagine the situation of a guy who ordered a portrait of his dog Fluffy in watercolors, but he got the portrait in acrylic. When Guy accepts the portrait as is after suing, the court will actually reform the contract to reflect acrylic. So the court goes back and changes the contract to reflect the outcome of the litigation. Reformation is sometimes used when a party makes a mistake, as in this example, where somebody thought they were buying mucklucks for $10 a pair, but in fact were charged $100 a pair. So the court can actually ask the retailer can ask the court to reform the contract to reflect the price of $10 a pair. So just imagine reformation as the court taking a pencil and changing the terms to reflect what the parties actually thought they contracted for. Okay, quasi-contract. That's just a fancy word that means, well, there's no actual contract, but we're acting as if there is one. Remember our first introduction to the concept of quasi-contract when we talked about promissory estoppel. Here we're talking about the situation where there's no contract between parties, but somebody gave something of value, whether it be a service or a good, to the other party, and now they want it back because the contract failed or the attempts to form an agreement failed. So there's no actual contract, but the value needs to come back to the original party, and that's quantum meruit, which deals with the value of the service, and quantum valabant, the value of the property. In my experience, parties refer to quantum meruit to cover both situations. Most people aren't familiar with the phrase valabant, but the book talks about it. Okay, back to our miner situation. In quantum meruit, imagine that there's no contract formed between a miner and, say, a locksmith, as in this situation. So there's no contract, but Amanda did get a benefit. She got an actual lock. So the locksmith can use the court's equitable remedy to get that lock back because Amanda had a benefit to which she was not entitled, even though there was no contract, or because there was no contract. Same thing regarding steak knives in this situation. Now, the concept of waiver basically means a party can give up their legal right to complain about something if they've taken a step that leads the other party to believe they're giving up their right to that complaint. Let's think of the situation where you pay your rent late to your landlord. If you pay it late and the landlord doesn't say anything and you continually pay it late, you have an argument that the landlord has waived the timeliness feature of the lease. Now, specifically for that reason, landlords often have a no waiver clause, and what they'll say is, I refuse to let one instance or several instances of a waiver or of me accepting untimely payment constitute a waiver of my right to collect timely payment. You see how that works. Waivers are supposed to be voluntarily giving up a known right. But sometimes people can argue that somebody waived a right without being fully aware of it. And so for that reason, no waiver clauses are fairly common. The next concept, mitigation of damages, is hugely important, and there are cases in every state on this topic. And what they say is a party can't recover damages when they should have mitigated their damages. In other words, they should have used reasonable efforts to go out and maybe we call it cover, get another one of the items, or maybe they should have taken other steps to prevent damage. Like in the consequential damage situation involving the refrigerator rotting, perhaps they should have moved the food from the refrigerator to another refrigerator. And if they fail to do so, then they can't recover because they failed to mitigate their damages. This is a very important theme throughout all of contract law. It puts the burden on the party who's suffering a breach to do something reasonable and fair to avoid further loss. And regarding Pioneer Exploration v. Rutherford, I'm going to ask you to tell me the holding of that case, which means the essence of that case, on the midterm. So be prepared for that. And that's it for remedies, one of my favorite topics. Gotta love the money.